Good afternoon, everybody, and welcome to the Samfiru Tumarkin live employment law show. We're on Facebook, YouTube. My name is Sandy Chen. I'm an employment lawyer with our firm's Vancouver office. I usually do these Q&A sessions every 3 weeks or so, but I'll be live for the next half an hour answering your questions, anything and everything to do with employment law. So if you have questions about, issues at work, issues with your boss, issues with a colleague, you want to ask about severance pay, or maybe you need to go on a medical leave, or anything to do with your work, you can just type a question in the text box in front of you, and then I'll be able to see it on my screen here, and I'll do my best to answer. So I have a few topics I want to talk about today, but I'll put priority to the questions in case I get any. The first topic that I like to talk about, and hopefully not everybody's dealt with this situation who's watching, is when you need accommodation in the workplace, right? And when I say accommodation, it could be, because you're suffering from some sort of illness, right? Or you broke a leg. It could be because you need to care for, you need some flexibility in your work to care for an elderly parent. So things like that. And there's an interesting case that just came out of Ontario. I think it's the Ontario Human Rights Tribunal, where the employer was the employer was asked to accommodate was asked by an employee to accommodate their need to take care of a parent who had been ill, and I think she was suffering from cancer. And so the employer had basically said, you need to come to the office every day, whereas this employee was previously fully remote. And at the end of the day, the tribunal did find that there was an obligation for the employer to accommodate this employee and give her more flexibility, because she had these obligations to her parent, right, to take care of her sick mom. And fortunately, the employee did succeed in that case. But that kind of just is an example of showing, there's situations under the law where an employer does need to accommodate an employee, right? The two most common are when employee is suffering from some sort of physical or mental illness, or they have to, they have certain obligations to a child or a parent, and the employer is under an obligation to accommodate those, to the point of what's called undue hardship, to accommodate the employee. Oh, we've got some questions actually. So first question is from Sammy. When is an employer allowed to change remote work policies? Who can they enforce these changes on? Yeah, so good question, Sammy. That kind of touches on this this recent case I just spoke about. There's a few different situations for remote employees, right? There's the people pre-pandemic that have always worked remotely, right? So the pandemic didn't really change anything for them. There's the people who were hired during the pandemic and they work remotely because of the pandemic. And then there's people who were in the office pre-pandemic, and then as the pandemic hit in March 2020, they all went, these group of people went remote, right? And so you have to look at it from two different perspectives, right? The first perspective is what does your contract say, right? If your contract says you're a remote employee, you don't have to go in the office, then the employer is not permitted to change change their policy with respect to you, right? You have a explicit agreement stating you're going to be remote, and so the employer cannot force you back to the office. Now, if you're not unionized, nothing stops the company from letting you go, but that termination would be considered what's called without cause, and you would be entitled to severance pay in that situation. Um, the trickier situation is where an employee was in the office and then they went remote because of the pandemic. And now, we're in 2024 now. The employer is kind of calling everybody back to the office, right? And that's more of a gray area, because if you've been remote for 3 years now, there's a good argument that's become a fundamental term of your employment, right? Because COVID, arguably, I know COVID's still around, but the pandemic was arguably over last year, right? And all the restrictions have been lifted for quite a while now. And so the argument would be they didn't call you back when the restrictions lifted, right? And so if they waited too long, there's an argument to say that the remote work is a fundamental term of your employment with the company. And if they try to change it now, you can refuse, right? And again, if the disagreement will be whether that's become a term of your employment. If it has, and I think some cases are making its way through the courts right now on this issue, for employees who were in the office, became remote, and now they're getting forced to come back to the office. At what point does it become a term of your employment, right? The second, so that the first way to look at this is at your contract, right? That's the first perspective. The second way you look at the situation is, is there a reason, right, that you need to work from home? Or to put it in other words, is there a reason that you cannot return to the office, right? For example, that the case I just talked about at the beginning of our session here, if you have to work from home to take care of a parent, or maybe you have child caring obligations, the employer has a duty to accommodate your need, right, to the point of undue hardship. And so what that means is, unless they can prove it's very, very difficult for them, for their business and their operations, to let you work from home, they arguably have an obligation under the Human Rights Code to permit you to work from home at least on some days, right? And the other example would be if you're suffering from significant pain that you can't commute to the office and you need to stay from home, stuff like that. So it's a good question. There's a lot of different, I guess, situations where an employer can force you to come back to the office, and then there's situations where the employer cannot, and it really depends on the specifics and the context of what's going on in your situation. So Samuel, hopefully that gave you some information. If you want to provide some more specifics about your situation, considering all the stuff I just said, I can do a follow-up question. Next question is from Peter. Your boss is very negative. He's very insulting when he talks about employees. The amount of stress and anxiety he is causing staff is considerable. Would there be any way to leave this environment and still obtain severance? Yeah, it's a good question, Peter. Yeah, there is. It's called a constructive dismissal, and what it would be based on would be, you could argue that there's a toxic work environment, right? And constructive dismissal, all that means is the employer has fired you without explicitly saying you've been fired, right? And so if you're going to work and people are just your boss and your colleagues are just bullying, harassing you all day. They're calling you names. They're putting you down. Um, they're just there to intentionally cause you mental distress, right? That's a situation where I could see you could leave and still obtain severance through what's called the constructive dismissal action. Um, it's it's a high bar in those situations. What I mean by that is, like, if your boss is just a negative person, right? Like if he or she is just a pessimistic, grumpy person, that's probably not enough, right? Um, it's the law looks at it from an objective perspective, right? And so what that means is it reasonable for someone to consider this a toxic work environment, right? It's not whether you consider a toxic work environment, right? Because you know everybody's different, right? Everybody has a different perspective on things, and so it's whether a reasonable person would consider it a toxic work environment. And that bar, typically, what our courts have said is fairly high. And so, if you're considering that path, I would just say you should speak to an employment lawyer first before you take that step, because the risk is, if you quit and you try to obtain severance, a court could say, well, no, you didn't have good enough reason to quit, right? This wasn't a toxic work environment, and then you're out of a job, and then you wouldn't get severance, right? So it's important in those situations to speak to an employment lawyer first before you take that drastic step of quitting. Okay, we got another question here from Linda. Can an employer let you go if a client saw you smoking weed off hours, not at or during work? Great question, Linda. So it's not a yes or no question, but let me explain my thought process. So if you are non-unionized, right, an employer can let you go at any time for whatever reason, right? As long as it's not like a illegal reason. So racism, sexism, nothing like that, right? They're just letting you go for whatever reason. They can let you go, but they have to pay you severance, right? This situation you're describing, it wouldn't be just cause. Generally, I would say it wouldn't be just cause. Generally, I can see where, if you're smoking weed just before you're going to work and you're a truck driver or something like that, like obviously that's a different situation. But speaking generally, your what you do on your own time is your own business, right? Marijuana is not illegal anymore, right? And so if I would say generally an employer decides to let you go, you're entitled to severance in that situation, right? If you're in a union, it's a bit different. You have job protection typically, right? And so you could potentially get your job back if they let you go and you're unionized. The other issue that this situation could the other issue, I think, is the human rights aspect of it. What I mean by that is, if there's cases, there's a lot of cases out there where someone's caught doing drugs or drinking on the job or coming into work drunk, or they get tested and it's for marijuana or alcohol, and it comes back positive, right? And what our tribunal and courts have said is basically, if the employer thinks you have an addiction issue, right? If you're addicted to marijuana, if you're addicted to alcohol, they actually have an obligation to accommodate you in that situation. So what that means is, they can't just fire you, right? Especially if because addiction issues are considered a mental illness, and mental illnesses are what's called a protected ground under human rights legislation. And so in that situation, then I mean, if hypothetically, let's say this person has, a an addiction to marijuana, and the employer let them go for smoking marijuana during off hours, that raises that human rights issue as well, right? As to and through the Human Rights Tribunal, they do have the power to order reinstatement if they want. So hopefully that answered your question. Then I think the short answer is, they can let you go if you're non-unionized, but they have to pay you severance, right? And then there's also a question of whether it's considered a violation of human rights legislation. And please feel free to follow up if I wasn't clear on anything. Got another question from Vin. You've worked 10 years. You've worked in a company for the past 10 years in middle management. Last year, you received stock options from upper management. The company has been bought over by another company and they cancel all options immediately. Can they do this? That's a good question, Ben. So I don't know, because when you receive the stock options, you probably signed an agreement, right? And those agreements are typically fairly lengthy. Assuming that nothing in that agreement gives them the right to cancel those stock options, they, and the stock options are worth, let's say, I don't know, let's say 20, 30% of your income, you could potentially take legal action, right? If if the stock options could not have been exercised anyways, or if you exercise them and they weren't worth very much, and you haven't really suffered any financial loss, it's difficult to say that they've breached. Well, it's difficult to argue that you've suffered any loss, right? You financial loss. And so the short answer is I don't know for your situation. But if you want, I can, if you're at BC, I'm happy to chat with you if you have the stock option agreements or anything like that. I think that this is a situation where you need to go see a lawyer and bring your documents with you so they can look it over with you. It's hard to kind of answer in this context, at least. Okay, we got more questions. Napoli is asking, do you need to legally give 2 weeks notice when resigning from a non-managerial role? Yeah, well, it's the issue of notice when you're resigning typically is governed by your contract, right? There's this rule of thumb where 2 weeks notice is sufficient, right? Sometimes it's not. Just like an employer has to give an employee reasonable notice, right? An employee has to give an employer reasonable notice. Now, if the contract says 2 weeks, that's considered reasonable notice, right? If the contract is silent, technically reasonable notice could be a few months, right? And the higher up you are and the harder you are to replace, maybe the more notice you have to give. The practical reality is if you give 2 weeks notice to an employer and they say, well, we wanted at least 3 months notice, in my experience, I've rarely seen employers go after employees for giving less notice than they'd like, right? It might be more common if you're an executive, right? And all of a sudden you leave, you give 1 day's notice, and then the company obviously will likely suffer financial losses that they could sue you for, right? And so I guess, to your question, 2 weeks notice, if it's in your contract, right, you should give 2 weeks notice. If your contract doesn't specify, then it becomes a much grayer area, and it could be less or it could be more than 2 weeks notice you'd have to give. If you're really concerned about this, just obviously speak to an employment lawyer, because the reality is a company is rarely going to go after an employee for giving less notice than they would have liked. I mean, it doesn't happen very often. That doesn't mean you shouldn't, give reasonable notice, but I think that's just the practical reality. I think we got a follow up from Sammy here. Employer is talking about installing cameras in the workplace. Where are these allowed to be installed? How much can they monitor employees through these? What is allowed in this situation? Well, they have to. Well, so the cameras can't record audio, right? Generally, because that's illegal. They can record video. In terms of the extent of where they're allowed to be installed, obviously not in private areas like bathrooms and stuff like that. There are, and I don't know this off the top of my head, there are decisions by the privacy commissioner here in BC about the extent of where the surveillance is allowed, and how long they can record for, right? If it's 24 hours or maybe only certain hours during the day. And the employer needs to provide some rationale, some basis for putting these cameras up, right? They can't just do it because they feel like it. And so there are decisions out there. I just, to the extent how much they're allowed to do it, or where they're allowed to do it at your office, I guess it depends on the workplace, right? If you're working at a bank, it's reasonable to think that there's cameras watching the tellers, right? If you're working at a restaurant or something like that, it might be reasonable to put a camera over top of the cash register, right? The cash register. But if you're working in an office environment, let's say an accounting firm, and the firm wants to put a surveillance camera in your office, right, directly above you, watching you 24/7, or at least the hours you're at work, I think they're going to need some sort of basis to justify that, right? I couldn't imagine what the basis would be, but there could be something. And so I guess, Sammy, the short answer to your question is it's context specific, right? Depends on the workplace, depends on the situation. It depends on, is there a history of theft or something illegal going on at work, right? I think these are all the factors that the privacy commissioner would take into account when assessing the reasonableness of these cameras. Okay, we got a question from Angie Wilson. You're only seeing offered 7 weeks severance for over 6 years in camp as a cook supervisor, and OFA 3 and a release of claims agreement. So, Angie, I assume your question is about severance pay and the release. So the release that they're asking you to sign, typically it's 1, 2, or maybe longer. It's one or 2 pages, and it essentially says that once you sign this, you can't sue them for anything to do with your employment, right? That's typically what it says. You can't sue them for overtime. You can't sue them for loss of benefits. You can't sue them for discrimination. It's a comprehensive release typically. And so you have to be very careful before you sign these things. And because you especially if you don't know what your entitlements are, right? In terms of the severance package they've offered you, it looks like they're offering you about a week per year of service, right? Maybe just over, because you've been there 6 years. They're offering you 7 weeks. Typically, a week per year of service is kind of the floor of what you should be given, right? If in BC we have the Employment Standards Act, which says you have to get a week per year of service, up to a maximum of 8 weeks, right? You know, there's into that's the floor. And so in determining your actual severance entitlements, there's um, a lot of different factors, right? The four that you commonly, if you do any Googling about this, you'll find, you know, age, length of service, how high up you are, and, you know, the availability of comparable employment. Those are what's called the Bardell factors. There's actually many more factors than just those four, but let's just take those four, right? Um, if you're older, you typically should be getting a bigger severance package. If the longer your length of service with this company, typically the higher your severance package, right? The higher you are, you know, the higher you, well, the nature of your position. So the higher up you are in the company, typically the more severance you get, right? Because it's presumed that if you're, you know, a vice president, it might be harder for you to secure a comparable job than, let's say, if you're kind of a, you know, a junior analyst or something like that, right? Um, and so, you know, in your situation, Angie, if you're comfortable disclosing your age and and all that, I think that's probably a big factor I need to know. I mean, if you're a cook supervisor and you've been there 6 years, let's say 5, 6, 7, 8 months, right, should be your entitlement. Um, but your age will have a big impact on that. Um, the one other thing I'll say, Angie, it's I've seen, the one thing I don't know about your situation is I've seen contracts that employees sign which actually limits your severance, right? And so what these contracts will do is, instead of, let's say, having to pay you 6 months pay, the contract says we will only pay you the minimums under the law, right? Which would be, let's say, 6 weeks pay in your case. And so that's a big unknown, I think, in your situation, Angie, is did you sign a contract or some sort of offer of employment that had one of these termination clauses, we call them, that essentially limits your severance entitlements, right? The I see you. There's a follow up. So you're 39, highest position, cross training all positions, and make daily wage 320 a day plus 50 a day. Yeah, Angie, it's 39 is kind of you're not. I don't, you know, you're not in your 20s, right? But your age shouldn't be a factor in. Um, your age should not be a factor in you looking for comparable jobs, right? So what I mean by that is, if you're 65, your age is going to come into account, right? It's not hard for an employer to look at someone's resume who's 65, sees all their work experience since, you know, 1975 or whatever, right? They can figure out they're probably near retirement. So at 39, you know, it doesn't make your severance isn't necessarily going to be more because of your age. In your case, I mean, let's say the range, if you've been there 6 years and you're 39, let's say it's between 5 and 8 months, right? I say it's a range because and I see you've looked into the Bardell factors, so you may have read it. It's not a science, right? It's basically it's basically you take the hundreds of, maybe even thousands of cases that have gone to court in front of a judge, and a judge says, okay, well, I'm looking at your situation, you get 10 months, right? Or I'm looking at this other situation and you get 12 months. So it's based on the cases, right? All we can do is look at cases in the past. Maybe a 39-year-old cook supervisor, right? And who's been with a company for 6 years, how much they've gotten, right? And I think you know, there's databases for this, but, you know, my guess is it's going to be, for you, it's going to be between, you know, let's say 5 to 8 months, right? Especially when you haven't signed a contract, which I think you just mentioned in your comment there. And so, yeah, I mean, it's let's say it's 5 to 8 months. The other big factor too you have to take into consideration is you the how long it takes you to find a job is actually probably the biggest factor, right? The purpose of severance well, it's supposed to be a buffer between jobs, right? And so if you find a job in 3 months, then you probably only claim for 3 months of severance pay, right? If it takes you 6, we can claim for 6. There is an upper limit, right? Like if you're out of work for 2 years, you probably can't claim for 2 years pay. So let's assume the upper limit's 8 months in your case. So I mean, I think the bottom line is 7 weeks is probably short, right? It sounds short of what we should be getting paid. With the only exception that, you know, if you have a job, if you have another job lined up where you're making the same money, you know, maybe 7 weeks isn't bad, but you know, if you don't know what's going to happen in the next few months, I'd say 7 weeks is very low for severance package for someone in your situation. Okay, I think we're out of time. I think I may have missed a question or two, so apologies for that. But I will be back in 3 weeks. My colleague Thielen is back. He's from Ontario, but he'll be doing a live show tomorrow. So if I've missed any questions, please be sure to tune in tomorrow as well. Okay, thanks everyone. I hope everybody has a great weekend.